Welcome to attend this session, Legal Aspects of Research Data. My name is Maria Rebinder. I'm Senior Legal Counsel at Aalto University, and I'm also Certified Information Privacy Professional, which is something that deals with personal data. This work is licensed under a Creative Commons Attribution International License, and this video will be available online. Today's topic is research data and legal aspects of research data. Why are we discussing legal aspects of research data? Because in order to produce fair research data that is findable, accessible, interoperable, and reusable, you need agreements about copyright, licenses for publications, documents that personal legislation requires, and all these are needed for fair research data. As I mentioned, today's lecture will be available online, so we are now recording this lecture. That is why the questions for this lecture, which I hope you'll have many, will be after the presentation. You can write them in the chat, but we will stop recording after my lecture, and then we will handle the questions after that. So please write them in the chat or ask them when we stop recording. So first, definition of research data. In the Open Data Directive, we have a legal document, the European Union regulation directive, which has the research data definition. Research data means documents in digital form other than scientific publications, which are collected or produced in the course of scientific research activities and are used as evidence in the research process or are commonly accepted in the research community as necessary to validate research findings and results. So this is the definition of the research data we are going to look at today. And the legal aspects that relate to this are intellectual property rights to databases, works and trade secrets, and personal data and the rights of data subject. So we are first going to discuss intellectual property rights, and the second part is about personal data. So intellectual property rights give the right holder an exclusive right to deny others from using their creation for a certain period of time. So it's a right to deny others from using, but it doesn't give you the positive right to use something if there are rights of other people involved. For example, if you have, like in the data set in Canada where I've linked, you have 15 researchers and more than one university producing a database. You need agreements, and in order to make that data set fair, you need to license it with a legal tool, standard license. So intellectual property rights are created by legislation, and then agreements are needed for using these rights. So these rights that are relevant for the database right are trade secret, which is valuable information not known to the public. How it's protected, you need reasonable efforts to keep it secret. Database right, which protects the content of the database, and that requires substantial investment in order to be protected. And then there is copyright, which protects original form, original literary or artistic form, and that exists when original form. So usually this is for the works inside a database. First, the sui generis database right, which is a right specifically created for the protection of databases, and a similar catalogue right. In Finland, these rights are legislated in the Finnish Copyright Act. And we also have in the Copyright Act this and catalogue right and producers' right and performing artists' right. So the Copyright Act has more than just the copyright. So a producer of a catalogue, which has made a catalogue or product, other product in where you have large number of information items compiled, has the exclusive right to control the whole catalogue. And this is producer's right, so it's born to the investor if this catalogue was compiled as part of employees' work duties. And the sui generis database right is similar, that it's protection of investment. So producer of a database who has made a database where the obtaining, verification, or presentation has required substantial investment shall have the exclusive right to control the database by making copies or making it available to the public. So here again, it's protection of the investment, and a university as an employer is the one investing if employees have made it as part of their work duties. So the sui generis database is born to the investor, and that means the investor has to invest financial means. So it is born for the employer. Of course, students who are not employed by the university are always owners of all of their intellectual property, including the sui generis database rights. So these rights are born to the students who are not employed by the university. Then the copyright, which protects original form. So copyright protects original form, not idea, information, or subject matter. Something is original if it's author's own original creation reflects their personality, and author has been able to express their creative ability by making free and creative choices and thus stamping their personal touch on the work. Usually the databases produced at university are created using a systematic form. So the goal is to make a database that can be clearly understood, and you don't usually try to have original artistic form for the database. So in the database, the content, the information is important, not the artistic form. So the Copyright Council has many statements on databases. These are in Finnish, but I guess you can translate them with Google Translate if you're interested. And in these statements, there's one example. Usually the databases don't get copyright protection as a database because they don't have that original personal form. So in order for it to be original, no one else would have such form, such personal expression in the form of the database. However, there can be protected works included in a database, for example, photographs, drawings, or literary sentences that are protected. So inside the database, it can be that there are included works and photographs protected by copyright, and then you need a permission or copyright exception to reproduce these materials in a database. For the use of research data, we have now an exception in the Finnish Copyright Act. This text and data mining exception was created by the DSM directive, and it has now been implemented into the Finnish Copyright Act. It will be in force the 4th of March. So beginning of next month, 4th day of March, this text and data mining exception is in force in the in the Copyright Act. So, for example, training artificial intelligence is a form of text and data mining. So, using the data for this purpose. And the new exception in Copyright Act is Article 13b, reproduction of works for text and data mining. And it states that whoever has legal access to a work may make copies of it for use for text and data mining and keep copies for that purpose unless the author has expressly and appropriately reserved this right. And the second part of the section legislates the rights of research organizations. So, for example, university that has legal access to work may make copies for text and data mining in scientific research, keep them for scientific research, including for later verification, and this use cannot be deviated from by agreement nor be prevented by technical means. So research organizations are by law have been created more rights for text and data mining than other types of organizations or individuals. Then the third intellectual property right we are going to discuss in relation to data is trade secret. So data protected as trade secret. Trade secret means information that has all of these following requirements. It's secret that it's not generally known to persons within the circles that normally deal with that kind of information. It has commercial value because it is secret, and it has been subject to reasonable steps by the person lawfully in control of the information. So, for example, data collected in a research project where the goal is to apply for a patent based on this information, that that database would be kept as confidential material, and the reasonable steps made would be marking it confidential and signing NDA agreements with all the researchers or other persons who have access to that data, which is confidential and which is meant to be a trade secret, at least until the patent application is filed. So we at Aalto University, we have the open data policy where we try to publish research data as open data when it's possible, but when there are trade secrets in the data, they must be kept as trade secret, for example, until the patent application is filed. And the trade secret is protected in legislation so that if you disclose a trade secret which you have acquired unlawfully, or if you breach a confidentiality agreement, then you breach the Trade Secrets Act, which is national legislation implementing the Trade Secret and Directive of the European Union. And so the rights were created by legislation, Trade Secret Act and Copyright Act. But the legislation tells you what kind of rights there are in existence. Then you need agreements and license in order to use them in your daily research. So one way of limiting the use of data is also technical measures designed to limit and block, for example, scraping of website. And in the Copyright Act, it says that it is infringement of Copyright Act to circumvent these technical barriers that prevent mass automated scribing. And usually you agree to these restrictions in the terms of the user agreement when you register as a user of that service online platform, or if you decide to use the website content. And as we discussed about the Copyright Act, now we have the text and data mining exception allowing research organizations the right for text and data mining, which cannot be restricted by technical means. So now research organizations should be able to text and data mine also this type of material. We'll see how this works in practice. As I said, the new exception is not yet in the national legislation, so we'll start using text and data mining according to that when it trades into force the 4th of March. And in order to use copyright and other intellectual property rights that are born to the individual, so copyright is born to the individual researcher as a person, they are transferred to university with Annex 1 of the employment contract for externally funded projects. So in the externally funded projects, the project funder requires that the beneficiary of the grant, Aalto University, is the owner of the intellectual property created in that externally funded project. And in order to fulfill that requirement of the funder, university needs the rights of the individual authors to copyright and to other intellectual property rights that may be created in that project, including different rights to data, if they are not already born to the university as investor. And this is one agreement that is used in order to make, for example, research data fair. So if university owns all the different rights, for example, from 15 researchers, then that can be licensed, for example, a database. However, for publishing, university has a grant back policy. So for publications, researchers sign the publishing agreement as owner of copyright. And for these publications, if they are created in externally funded projects, the principal investigator checks that there are no trade secrets or patentable inventions before a patent application is filed. But there is a grant back policy for publication. And in a way, this also is relevant to publishing databases, or this is relevant for publishing databases because the research data policy, open data policy of university has as goal open research data. So this is usually has been any researchers who wish to publish, they can publish their research data if there are no other rights to that. For example, something promised to the funder, trade secrets or patentable inventions in that database. And one type of agreement is license. So research data, you can have the agreements between two organizations on research data, but you can also have licenses that give rights to many users. So, as already mentioned, legislation defines the scope of intellectual property rights, when they are born, to whom, to what entity. So copyright is born to the natural person, the author, the researcher, and sui generis database right is born to legal entity, the investor as employer. And intellectual property legislation is contractual. This means that in practice, when we look at the data sets and we ask, what can I do with this data set? You have to look at the agreements, licenses. So contract and permissions, meaning licenses, define how intellectual property rights can be used. And in order to make data and other publications legally interoperable, we use standard licenses such as Creative Commons 4.0 family licenses. These license copyright, and these licenses also license the European sui generis database rights. That is the newest family of Creative Commons licenses. There are 6 different licenses in the Creative Commons family, and the 4.0 license family is the newest one that takes the sui generis database right into consideration. So as stated in the beginning, legal interoperability is one requirement for fair research data that is findable, accessible, interoperable, and reusable. And we have in the Open Data Directive of EU, Article 10, which states that member states must have national policies aiming at making publicly funded research data openly available, following the principle of fair data. So this fair data principle is now part of EU legislative tools, the Open Data Directive. The Open Data Directive has legal requirements for open publishing of research data. And in Finland, this directive is not in the Copyright Act. There is a special law, Act on the Reuse of Research Data subsidized by public funding, laki julkisin varoin tuotettujen tuotetuista tutkimusaineistosta. And this act and the Open Data Directive requirements apply when all three of these requirements are filled. So research data is resulting from research subsidized by public funding. That means it doesn't have to be external funding. The university basic funding is also public funding. It is made available to the public, so the decision to publish it has already been made, and it's published in an institutional or subject-based repository. So the Act does not require opening of research data, but if you open the research data and it's subsidized by public funding and it's published in an institutional or subject-based repository, then you need to license it with the license required by the Open Data Directive. And as we started, the Open Data Directive has the definition for research data. Maybe just as a note, definition of document not intended to cover computer programs. And of course, the national legislation has the same definition as the directive. And recital in the Open Data Directive clarifies the repository, which is meant, and there has to be possibility to use it for both commercial and non-commercial purposes. The license should be in machine-readable format, and it should be a standard license, which is defined that the license should have predefined reuse conditions in a digital format and standard terms for the use. And the recital states that open access data should be without restrictions on use and reuse beyond the possibility to require acknowledgement of authorship. So when to find a license that requires all these requirements are filled, the license is this Creative Commons Attribution International, or for short CC BY 4.0 license that is compatible with Open Data Directive and the Finnish national legislation implementing the directive. So if you have publicly funded data that is published in a repository, then this is the license that is required, or a similar license, but this is the standard. And when you are trying to find interoperability, then a global standard license, which is very widely used. There are this is the open science license. Of course, you can also make the data even more usable by CC0, which is a waiver of all rights. So that was the intellectual property part. The research data that includes personal data has different type of rights. So these rights are the rights of data subject. So the person whose data is processed. So, for example, a person participating in the research, person giving interviews, answering survey questions, they are data subjects. And the personal data legislation deals with their rights and risks for the use of data are evaluated from the viewpoint of the data subject. And the European Union Charter of Fundamental Rights has two separate fundamental rights. One is the right to privacy, and as separate from that is the right to personal data. So even if it's not about private life events, even if you are interviewed as a professional in your professional capacity, it's still personal data, and you should write the privacy notice and inform the data subject on how the data will be used in your research and possible publications. Will the publication have the interviewed person's name or just the role, for example, researcher, lawyer, or the job title and organization, and so on. So interview, survey data, very usual types of personal data used in different research projects. One solution for dealing with personal data legislation is to try to anonymize the data, or even better, try to collect the data without identifiers. But often anonymization is not required. And it's also very difficult to achieve. So there are different anonymization techniques. Others in the research services are expert on this, but generally in the privacy notice where we tell how the data is processed, we usually just explain what are the identifiers that are removed and what are the identifiers that stay in the data. And I haven't had any cases where we would actually be able to say that we have achieved anonymization so far. But of course, it's always a possibility. Just be very careful about it. It's better to just explain how you're going to process it and not to promise anonymization if it's not possible for that type of research data. So any analyzing of data is processing personal data. Also, the anonymization process is one part of processing personal data. And when you are processing personal data, the processing must be transparent, lawful, and fair. And transparency means that you are telling the data subject what you're going to do with the data. Lawful means that you need a lawful basis for it. And then the other, it has to be collected for a specific purpose. And it can be also processed in a manner that is compatible with those purposes. And whenever you should follow the principle of data minimization, accuracy, storage limitation. So don't collect unnecessary data. Don't store the data longer than it is needed. Take care of the integrity and confidentiality of the data, accuracy of the data, and then accountability, which is the requirement in GDPR that you have to be able to prove that you have followed the legislation. So usually you are innocent until proven guilty, but for personal data, you have to be able to prove that you're following the legislation. So you need the documentation, the privacy notice explaining the data use and a plan for the data use, and you have to be able to show the security, secure storage, and so on for the data. So, and there always has to be a data controller that is accountable for the employers. University is the controller who is accountable for the use of personal data. And for students, usually it's organized so that the students are controller, or the company where the student is, for example, doing their thesis for. The GDPR takes scientific research purposes into consideration. And according to GDPR Article 6.1, subsection 1, section E, one legal lawful basis for processing is that processing is necessary for a task carried out in the public interest. And in national legislation, it is possible to legislate that processing that is necessary for scientific research can be a task carried out in the public interest. And in Finland, we have in the national legislation, in the Data Protection Act, defined that scientific research is a task carried out in the public interest according to GDPR. So we use this often as lawful basis for the processing if it is scientific research in the public interest. And also you can use consent as a lawful basis. The problem with that is that the data subject has to be able to withdraw the consent as easily as it was given. And when the consent is, if the consent would be withdrawn, there's no longer a lawful basis for the processing. Not all EU member states have this national legislation. So if you have an international consortium, for example, EU project, it may be necessary to use consent as lawful basis anyway. And the transparency, inform the data subject, and this has to be done before starting of the collecting of personal data. And you give this to the data subject in a privacy notice. And the privacy notice should be concise, easily accessible, and written using clear and plain language. So the easiest is just to explain what you are going to do with the data. We have a template for this, and it has some examples, but don't follow these examples if they are not relevant to your case. So just use clear and plain language and explain what you are going to do with the personal data. And GDPR has a list of information that needs to be in the privacy notice: identity, contact of the controller, purposes of processing, legal basis for processing, categories of personal data, rights that the data subject have. Is the personal data transferred outside EU? Data retention time or criteria for retention, and contact details of the data protection officer and researcher, and also the national supervisory authority. We have guidance in Aalto website, and also many publishers require an ethical evaluation if you have human subjects in the research. So the research ethics committee statement may be needed, and that is also needed before you start collecting the personal data. So please contact the research services or your school lawyer before you start processing the data. So you can get help if you need help for the drafting of the privacy notice, and the research ethics committee if you're going to publish research articles based on research data that where you have used human subjects. So check check the requirements of the publisher you are interested in. And transfer of personal data to countries outside EU, and there are adequacy decisions. So, for example, United Kingdom has an adequacy decision. So, in practice, transferring data to UK is done similarly than using the data in EU. Just state in the privacy notice that it's going to be available for a UK university, for example, and legal basis for transferring the data to UK is the adequacy decision. And for other countries that don't have adequacy decision, we use the standard contractual clauses. Please contact your school lawyer if you are taking personal data outside EU and the country doesn't have the adequacy decision there. All the adequacy decisions are published in the website. The link is there. So there's already quite a lot of legislation relating to research data, but we are going to have, and we already have some new EU data legislation. So creating a data economy in the European single market is the goal, and EU is harmonizing rules on data sharing and giving people more control over their data. There are 5 new data laws and proposals for legislation, and this will reshape the data economy in Europe, and this legislation will affect research data in some ways, but exactly how remains to be seen, and we are following this legislation closely. And these are some studies on the Open Data Directive, Data Governance Act, and Data Act, and their possible impact on research. So these are EU publications written by prominent European legal experts. These were published quite recent. I attended a workshop in Brussels organized by the Commission where we heard these experts on the subject of the new data legislation, and it's still on the. We're still talking about possible impact on research data. So we will have I'm sure a special lecture session, training session on these when we have a more clear picture on the practical implementation of this data. But anyway, the Open Data Directive is lex specialis on research data. So the effects on the Open Data Directive are already known, as we discussed previously. So to summarize what we have discussed today, the legal aspects of research data. So databases are subject to legislation and agreements. Intellectual property legislation creates rights that are relevant for databases. Data can be a trade secret. Licenses define how intellectual property rights can be used. And Open Data Directive affects the choice of licenses. Personal data legislation protects the rights of data subjects, and legal bases and privacy notices define how personal data can be used. So this was my session on the legal aspects of research data.